Hello, everyone. Happy Friday. Happy day before. It's two business days before this update comes into effect on the 1st. We had two pretty significant sessions. A lot of time and effort went into the past 2 Fridays. Today will be a little more casual. Some of you have sent your questions in beforehand, and thank you for that. Had a little bit of chance to process them. I have 2 recordings so far. The first 2 sessions are recorded. I'm going to record this one as well, and I'm also going to send all 3 of the links out in a final recap email. So you can look out for that. And Vince, I think you're going to provide an overview, and then we're going to get into the questions. So I'll be monitoring the questions box. If anyone has an issue of use the questions box instead of the chat, I prefer that one window to look at. And Vince, take it away.
Great, thanks, Drew. Welcome, everybody. This is the 3rd of our series of presentations concerning the new TIRSA manual that's effective actually now next week on October 1st. As you know, 2 weeks ago, we did our first session on the manual itself and giving an overview of the manual and what's new in it, going over the terms. Then we also talked a bit about the base policy forms. And as we discussed in that first session, of the several main things that this manual does, one of the main things that it does is that it replaces the 2006 vintage of owners and loan policies with the 2021 vintage of owners and loan policies. So that's a big change that in turn means that certain endorsements that we provide today do not need to be provided in the future. I'm talking about the policy authentication endorsement, tribal waivers, the jurisdiction endorsement with regard to tribal Indian tribes. And in the following session last week, we covered all the new endorsements that came out. Now, just as I was mentioning that the initial policies were changed from the 2006 to the 2021 version, in this case, most of the endorsements that actually came over are of the 2006 vintage. So that's one thing to keep in mind. We asked you during both of those presentations to think of questions as time has gone on, and as these things have had time to percolate. Hopefully you all have some ready for us. We have accumulated several that we'll talk about during this session. And I think that's about it. Catherine, do we have any questions already lined up?
Sorry. Yes, we do. But before I start, I just want to point out something. We have all these crazy endorsements now. We have the 18 series and the 9 series, and you're looking around for what you can use. I want you to not forget the residential endorsement that you usually use, 1 to 4 family. It does have a lot of coverage in there, violations of covenants, enforce removal of any improvement as a result of encroachment on an easement. So a lot of what you have in the residential endorsement will also apply before you get into these specific situation endorsements that may be a good general fix. Getting into the questions, we'll start with this one. One of the agents had asked, are we still raising out of possession? The answer is yes. Whether we include out of possession language is unaffected by the new TIRSA manual. However, when affirmative insurance is sought for such variations that you have with this out of possession, you can use either the 28.2-06 and describe the encroaching improvement in paragraph 2. So say you have out of possession a fence over 2 feet or a shed encroaching on the neighbor, you can use 28.2-06 and you can put in exactly what the improvement is. And that will cover you for that type of situation. A big question for us is what endorsements need approval from the underwriter. You have to consult the rate manual for that, which is now available on the TIRSA website. We'll be sending that around today. But in a nutshell, the ones that you usually use, the 9 and the 18, they all require, almost all require underwriter approval. A lot of the new endorsements require underwriter approval. Now that means you have to get the requirements for that endorsement, make sure you have all of them, and then present them to your underwriting counsel for review and approval of that form before you can use it. And we will help you tweak it, fill in the blanks, whatever it is, but that's the way it is. That's very cumbersome. So what we're trying to do, and we're still working on it, and maybe it's in good shape right now though, is we're going to try to make an electronic underwriter. Meaning when you choose the Alta 9.1-2 or whatever, you're going to have a pop-up, and the pop-up is going to say, these are our underwriting guidelines, check them off as you have accepted them. And once you have fulfilled all the requirements of that particular endorsement, and you can attest to that, the endorsement will release and you will have it for your policy. So we're trying to streamline that so we don't get 100 calls a day and you don't have to call us in every single file just to issue an endorsement. But that's a pretty important one. So we're going to try our best to make it easy.
Sorry, Catherine, I just, would you say that a lot of the tasks that are required for these endorsements are tasks that the agent's probably already familiar with to a certain degree?
Yes, I would agree with that statement. You're always going to need a survey with the 9s and the 28s and the minerals. You know, you're going to need to review the survey as you usually do, see where the encroachments are, and raise them as exceptions. And you're going to see whether there's enough, you know, if you can give the coverage that's required by the lender for this particular endorsement. So you're going to look at your surveys, you're going to look at your CNRs, and you're going to compare them as you usually do to see what the encroachments are, what the violations of the covenants and restrictions are, setbacks, and you're going to raise them all as exceptions, and then you're going to give the affirmative coverage for anything else that might have been missed. So yes, a lot of it will be the same type of thing you're already doing.
In your experience, I mean, you see so many, we both see so many surveys, you see even more than I do. Do you think that, is the current, you know, are the surveys that you see on a daily basis, do you think that they have the information that's going to be needed for these endorsements, or do you anticipate that, you know, there's going to need to be more back and forth between our agents and the surveyors to say, hey, look, you know, we believe that there's an easement somewhere here. It isn't plotted out on your boundary survey. You know, we need you to go back and do that. You know, we need to see what the effect of, you know, this nearby improvement is on the property. You know, do you think our surveys that we're getting right now are up to this task, or are we going to need to kind of help out those surveyors?
No, I think the agent should be proactive. You know, when a good practice when ordering a survey is to send them the abstract so that they see the easements, the covenants, restrictions, the driveways, whatever might be necessary, and they can plot them. And then once they plot them, you'll know whether there are any violations or not. Otherwise, you have to say, oh, there's a telephone easement 5 feet along the back line. How does that affect my property? And you're going to have to do it yourself. So the better practice is to, when you're ordering the survey, give them the covenants and restrictions and the easements so that they could plot them, so that you have the information straight away in front of you to make the decision as to whether to issue an endorsement, or at least allow us to make the decision. A lot of these surveys that I see, they don't really plot anything. They just do the basics. A lot of them have been having errors lately, especially with leaving out setbacks on fences or sidelines. You know, they need to be complete surveys for you to read in. You have to be very careful with that.
You know, it's almost about whether we might want to eventually advise that we tell the surveyor what endorsements we're contemplating issuing. You know, it's something just occurred to me as you're talking, but you know, if we can educate the surveyors on what type of coverage we're going to be issuing, they might be able to better anticipate what we'll need.
It could be. I mean, a couple of surveyors that I know can do Alta surveys, and Alta surveys are kind of like a super survey, and they have a lot of these things. So the surveyors do have the ability to do all this, and you know, maybe educating them on what we're trying to accomplish, they'll help us with giving us more information on these.
Great, and that's a great suggestion about providing them the abstract.
Thank you. You know, now we had a question about what about the age of the survey? You know, can we use an older survey in a survey inspection? Well, you're not going to like this answer, but it depends. If you do a survey inspection, it has a million fences and a shed in the corner of the property that are not located, you're not going to be able to issue an endorsement for those things. So I would say a current survey is the most valuable thing. If you're, you know, insuring a row house in Brooklyn, there's not going to be any change for 100 years. You know, they're going to be party walls, the fences have been there forever. You know, you're going to do an inspection and nothing happens. If you have some upstate property, some new construction, something like that, you're going to need as current a survey as possible. Vince, you have any other questions?
Well, we were also asked about, very practical, where can our agents get a copy of the manual? And as we know, I think there's some recent developments right now. You know, in the past, I think 48 hours, TIRSA has now uploaded the manual to their website. So for all of you that have been waiting for an authoritative copy of the manual, you can download it there. You can also tell your clients that they can download it as well. We've also been asked, let's see, another question that we've been asked is, are there any new exceptions for discriminatory PNR? And actually, the answer to that question is that that's now part of the boilerplate. So in fact, there's less of an exception that you have to add. There's really no exception you have to add. It's all admitted. It was all handled right within Schedule B itself in the lead-in paragraph. And that actually brings up another question regarding the rate manual. About the transaction identification information, which is a part of Schedule A. As you'll note, when you take a look at the manual itself that was filed, there's a block of options that resides above Schedule A, and it talks about an Alta registry ID. And we had a question recently on this about what do we put in for that ID? Well, the first thing you should do is you go to the Alta website and look yourself up in their registry ID, and if your organization has a penguin, you should be able to find yourself listed there. It's a free feature for any member of Alta. It is not mandatory at this time, although I could see that lenders might be interested in having their service providers all get a Alta registry ID, but that registry ID correlates to the actual issuing office that is issuing the title insurance policy. So I just wanted to clarify that. Let's see.
I want to go over some of the exceptions that you usually put in your policy that have affirmative insurance already. The first one is for condos or PUDs, where it says any state of facts an accurate survey may show, including possible encroachments upon the unit. This policy, however, ensures that encroachments by the insured unit upon adjoining units may remain undisturbed. Take it out. You're going to take out that second sentence that says this policy, however, ensures the encroachments to be insured may remain undisturbed. It's free form affirmative insurance and it should not be in your policy. So take that exception and cut it in half and take out the affirmative insurance. It's in the condo endorsement. It's in the PUD endorsement. You really don't need that language within your title report, and now you have to technically rip it out. So please get rid of that language. The second one is the one that you usually do on refinances. It's a big paragraph. It says policy accepts covenants, restrictions, easements, agreements, etc. of record, if any. However, policy ensures the same will not interfere with the use of the building currently on the premises of the dwelling. Policy ensures that a future violation of the same will not result in a forfeiture or reversion of title. That all has to be taken out. The only thing you can leave is that policy accepts covenants, restrictions, etc. That refinance paragraph should not be used, or you can just cut it down to that first sentence. So those are some of the standard ones. I'm sure there are more exceptions that you put in that automatically have some sort of affirmative insurance. The point is there shouldn't be anything in Schedule B that has anything to do with affirmative insurance. You keep the first statement and you get rid of the rest.
You mentioned the residential mortgage endorsement. There's also the condominium endorsement. And a lot of times, affirmative insurance people ask for condominiums. It's already in that endorsement, isn't it? For the most part.
Yes, the condominium endorsement and the residential endorsement shouldn't be used in conjunction with each other. They're not compatible. The condominium endorsement has enough for the condominium to not need such extra language.
Gotcha. You know, we got a question, as you know, about the Alta Twin endorsement, and there was a question about how to actually draft that endorsement really well. And thought I'd just mention that the question had related to the fact that part of the endorsement refers, paragraphs A and B refer to that they're providing coverage unless accepted in Schedule B. But then the other two paragraphs do not reference Schedule B as limiting their coverage, unless you then go ahead and again further specifically identify the exception within Schedule B. So if you wanted to remove from coverage items from 3C and 3B of the 28 series of endorsements, what you'd have to do is raise a matter in Schedule B, let's say B1 covenant restriction in library, whatever. You would then also have to list in the endorsement that specific Schedule B exception to remove it from coverage. But anyway, part of the endorsement provides, by default, provides coverage unless it's accepted in Schedule B, and part of the endorsement provides coverage irrespective of whether it's in Schedule B, unless you then specifically identify where in Schedule B.
Exactly. If you're using the 28.2 and you have fence variations, which is the beginning of the question that we received, you know, we're not insuring against, you know, monetary loss, but you're going to put that into 28.2. You're going to fill in that blank to say, okay, it's the fences that we're insuring the variations on. But if you have an owner's policy and you're putting in a 28 series endorsement into that, if there's an out of possession, that's going to still be an exception. You know, any violations, any out of possessions, you're still going to accept them in your survey reading, or, you know, if there's a setback violation, you know, in a CNR, you're going to accept that there, and then the endorsement covers the rest. So you have to be very careful with drafting these. When you're doing something specific like a fence variation, you're going to put fences in the endorsement itself, but the out of possession is the minus. Like, we'll insure the fence variations, but we're not insuring the out of possession for a fee. So exception number 4D is, you know, still going to be, you know, omitted. You know, it's still going to be accepted in your coverage. See what other questions we have. Go ahead.
Another question. Is it okay to have the acronym ATMA as their interest may appear in loan policy? Is that affected by this manual?
That is not effective. We got that question because a lot of people put as their interest may appear, and in our last session we said, no, you can't use that anymore. You can't use it anymore on owner's policies. It's completely fine for loan policies because those are an instrument that gets assigned. But for owner's policies, you cannot put ATIMA unless it's USA or a nominee pursuant to a nominee agreement. There's one other issue, but I can't remember it right now. But there's only those cases where you can put ATIMA on an owner's policy. Loan policy, perfectly fine. It's a good question.
You know, Catherine, I remember we were talking earlier this week about a question that we had that wasn't exactly necessarily addressed in this manual, but it was a question that we had about when you have a $1 condemnation clause, and whether there's any kind of insurance that we can provide. One of the agents asked about affirmative insurance, and as we know, we're doing away for the most part with free-form affirmative insurance. But is there anything we can tell them about our ability to ensure a $1 condemnation clause?
$1 condemnation clause is a tricky one. I mean, it's the city saying, selling a property to a person, or an entity, a party, and saying, you're getting a good deal here. This is practically a condemned property anyway. We're going to give you $1 if we ever condemn it. If you don't build right or whatever. If we want to take it back, we're only going to give you $1 for it. So in the past, people would give affirmative insurance for a diminution of value, which, insures against diminution of value, saying, lender, I know you lent $200,000, but if the city gives you $1, we'll make sure there's no diminution of value of the property, and, they should really give you $200,000. We can't insure that. We don't know what the city's going to give you. The city may just give you $1. They could give you fair market value, but there's nothing we can insure against. That was kind of a insurance that never really should have been given. So if you're issuing a 28.2 or something like that, and for something else, you're going to have to make sure in that paragraph 4 that condemnation clause is not one of the things you're covering. If you're covering the rest of the CNRs, encroachments, whatever, easements, make sure you accept that one, because there's really no equivalent coverage that we can give for that. It's just like a street widening. They said, oh, well, can you insure this land? We're like, well, the city's going to do what the city's going to do. If they knock down your stairs or they knock down your building because it's in the proposed widening area, there's nothing really we can do about it. We can't insure against that. The city's going to do what the city's going to do. And in the policy itself, it says we do not insure against condemnation, eminent domain, anything government, anything zoning, anything to that effect. We don't insure it. So we can't now put it back that if there's a $1 condemnation clause, we're going to now insure that particular situation. Because it's like insuring a certificate of occupancy search. We're not going to cover that. We never cover that. We shouldn't cover that.
Right. Thank you. Thank you. That's good. Hey, I'm not seeing any questions popping up in my head.
Yeah. Another question was, are they eliminating the market value rider for both the standard and the taupe policies? Did you get an answer on the taupe? I mean, it's gone for the taupe, but we were trying to determine whether the market value now covered both policies. Did you ever receive an answer on that?
You know what? I have not received an answer on that yet. However, looking at the manual and looking at the remaining market value rider, they did remove the rate rule for the taupe market value rider. And the market value rider that still remains refers to the wrong condition. It would have to refer to a different condition in order to actually operate. So that might be something we will have to restore in the future. I do not know. I have not yet hoping to do that.
Some questions, unfortunately, are still not answered yet. So we there's an option rate something outstanding. So there are still some things in progress, not at our level, at the next level, up at the TIRSA level. So we'll get answers to you as fast as we can.
And that's a good point. We should also probably mention there's some other. I'm sure most of the agents do not use the junior loan policy, but one of the things you might notice is that the junior loan policy is still in the manual. The rate rule for it is gone, but and two endorsements that are kind of needed for it are still there. So there's still some things that need to be clarified. And the market value rider is the other one. And as Catherine mentioned, there's some other portions of the manual that we're still looking at.
Okay, thank you. The only other question I see that we have, not sure if we have any other questions. The last one I see is, can the Alta 9 series endorsement be added to the loan policy? It's not just one endorsement anymore. Each endorsement in the Alta 9 series does a different thing. So there are 4 for the owner's policy and there are 4 for the loan policy. And each is done separately, depending on the situation. And a lot of them cannot be issued in conjunction with each other. Like if you have one that's for improved land and you have one for land under development, you have to pick one. You have to know what the stage of your property is to choose something. So there is the Alta 9 available, but you have to figure out which one to pick. And we will help you do that because these are endorsements that require underwriter approval.
Catherine, another question that I noticed, and this really doesn't speak exactly to the manual, except by way of the fact that the manual tries to do away with affirmative insurance. And that was that this agent had been in the practice of providing this language when there would be, let's say, like a 0.9 foot variation in a fence. No loss in monetary value to be possible out of it. And I think we talked a little bit about the types of things in general that we're able to insure. And I think we both came to the conclusion that things like monetary value have never really been something that we could be insuring.
Yeah, that's true. The good thing about the manual, as it is now, eliminating all this affirmative insurance, is it doesn't have to be the Wild West anymore. For fences, I've probably seen a dozen different variations of affirmative insurance, and what the manual does by eliminating all the affirmative insurance is making it uniform. Now, everywhere you go, if it's a fence, if it's a shed, if it's a fountain, it's all the same due to the enforced removal, loss or damage due to the enforced removal. That's what you're going to see a lot in these endorsements. So it's the enforced removal. It's a court order. It's a government edict. It's not just, hey, you have a fence in the wrong place, we're going to insure you against monetary loss. It's too broad. That's too automatic. Monetary loss for what reason? It has to be something that's enforceable. Someone is forcing you to do that by court order or a government edict.
Well, the good news is it seems like our agents are just going to use this, because I'm not seeing any questions pop up in the chat.
Drew, do you have any questions for us?
Nope, I don't have any. Sorry, I can clear my throat for you, but I don't have any questions.
Okay, we had another question about the tow policy market value rider to see if it's a replacement, and we're going to check on that information. I am not seeing further questions myself. We're going to put out a lot of information before October 1st. What you're going to see is the rate manual, which is already on the TIRSA website. you're going to see an endorsement manual, which will tell you every single endorsement, their price, their purpose, and their underwriting requirements, so that if you have one of these, you can collect the information in the underwriting requirements and send it to us for approval. That will help you decide which endorsement you need for what situation you have. We're going to give you the codes for remittance. We're working on a cheat sheet to kind of say, okay, if it's fences, where do I look? There's covenants or restrictions that are violated, what do I do? And a bit of a mini underwriting guide for the 9 and the 18, which will probably be your most used endorsements residentially. And we're going to put out a new exceptions manual. The exceptions manual is online, and this all will be online in the in eSecurity Connect. But there is an exceptions manual online. It will be replaced by a 10.1 exceptions manual, basically tearing every single piece of affirmative insurance out of it. So there's going to be a lot of redaction of exceptions, an entire affirmative insurance section that you're used to seeing it, and it will be a new manual. We had also updated with a few exceptions that were missing for certain subjects. So that will be available. We will also be sending that out so that you have full exceptions for security title matters. And I don't think I'm missing anything, but you should be doing the same with your own. Everyone has electronic databases. Everyone uses Tracker Pro or AccuTitle or some sort of production software. You should be making sure all your affirmative insurance is gone. Have someone go through all the exceptions and then just delete them so that you don't accidentally put it out there when you're doing a refinance with that big paragraph because it's in your standard exceptions. So that's a task for you to make sure yourself that no affirmative insurance goes into that Schedule B or survey rating.
You know, Catherine, you actually just brought up something that reminded me. And I'm not sure if you mentioned it as among the endorsements that'll be most commonly issued. But if I could just point out, I think one of the endorsements that I would encourage people to take a closer look at. Of all these endorsements, particularly if you're concerned about affirmative insurance and survey readings and things like that, I would encourage you to take a look at the ALTA 28.2-02, because this is an endorsement that enables you, like, affirmative insurance for the most part, when it comes to things like survey reading, it's because you've identified a particular thing that you find problematic. It isn't a request, about a CNR or something like that. It's because, okay, there's a fence, something you've identified that you want to find some kind of affirmative occurrence on. 28.2-06 enables you to identify the improvement that you want to provide the coverage for, and you can be very specific about it. And it is that endorsement that I was mentioning. It operates by accepting from coverage by default under paragraph A and B, everything that you've identified in Schedule B. But under C and D, you can still have it in Schedule B, and as long as you don't specifically exclude it under paragraph 4, you're providing them some kind of affirmative insurance. So I would encourage you to take a look at that. And try to be familiar enough with it that you can point your client to that endorsement possibly when they ask you for certain forms of affirmative insurance.
I brought up one more point on the residential endorsement. I brought up before that the residential endorsement does insure against violations of covenants and restrictions and enforce removal of improvement over an easement or some sort of encroachment. I had a question about, do you need a survey for a residential endorsement? And typically, you give them out like pets, you just hand out candy and give it to the lender. But technically, you really do need to have a survey for a residential endorsement. because you're ensuring that there are no violations of the covenants and restrictions, there are no encroachments of the building into any easements or anything. How can you do that if you don't have a survey? So that is something for you to contemplate, that you are doing a lot of the same things you're supposed to do, but you still need a survey for almost everything. You're always having to read your CNRs in conjunction with your survey, in conjunction with your description, and making sure that we're not missing anything. We are accepting the CNRs of the policy, but if there's something specific, like the building is 40 feet and there's a 50-foot setback line, we have to put that out specifically. Otherwise, we may end up having a problem defending that if there's ever an issue.
It's a good point. Another thing I would mention about the endorsements in general is that, the 1-9 series of endorsement that we're using is the TIRSA 9 for restrictions and encroachments in minerals. And if you look at the rate, if you were to look at the rate filing letter that TIRSA filed, they mentioned that the TIRSA 9 is being replaced by the Alta 9s, but it's actually more than that. That in a large way, the 28 series and the 35 series are also kind of replacements for the TIRSA 9. The TIRSA 9's coverage was really kind of broken apart and broken apart into all these different endorsements, and that's really what you're seeing. The closest thing that you have now to the TIRSA 9 is the 9.7, I believe. That's the only one of the 9 series that has been adopted in New York that includes restrictions, encroachments, and minerals. All the rest of the 9 series that were adopted are actually, they're a subset of coverage of the Alta 9s. And the 35s and the 28s all kind of came from that as well. So just like I would want to be familiar with the 28.2, after I got familiar with the 28.2, I would be looking at all the Alta 9s, the 28s, and the 35s. And you'll see they have a lot in common with each other. But you'll be working with them a lot, and working with us with them a lot. Let's see. So we all know the manual is going into effect October 1st. Let's see, let me check the chat. I'm still not seeing that we've gotten any questions. Another change, it's not a change that's actually happening in this manual, but it's something that might happen in the future, is all the forms in the manual were updated with a couple exceptions. And one of the exceptions is the tote policy. And for those of you who are familiar with the tote policy, the version that we have, even in this current manual, it's a very old version of the Alta homeowners policy. And Alta, time has marched on, and there's a 2021 version of the Alta homeowner policy. If I were to make predictions for the future, I would predict that we may be seeing those policies updated as well. Another interesting thing about the new thing about the revised manual is that it actually does introduce a couple new endorsements that do not have an analog today. And one of those is the zoning endorsement, which basically, I'm just going to bring it up here for my own use. The zoning endorsement will actually give rise to a new search, I'm sure, a zoning search. And in that endorsement, you basically state that the land is in a certain zone, and you then recite the different uses that are permitted under that zone. So that's something we might be seeing some requests for in the future. There's a couple others. We're actually going to be going over, and you'll see seeing a memo from us soon, which explains in detail which endorsements have been withdrawn, which endorsements are being replaced, and naming these new endorsements. There's another endorsement, the usury endorsement. This isn't one that you're probably going to be using every day because it's only for mortgages of $2.5 million or more, but it insures against violations of state usury laws. There's also a new endorsement, at least new to New York, which is a 40 series, which is about tax credits for possible tax credits under the Internal Revenue Code. And I mentioned in the last seminar that they created a more limited version of the mezzanine finance endorsement, which basically just adds another entity as a loss payee, essentially.
Hi, sorry everyone, I was muted. We're having technical difficulties. Something else I wanted to bring up, another question I had is, do we have to issue separate endorsements for each item? And that's a really good question. The answer is, of course, it depends. If you're doing, if you have 3 easements, a water, an electric, and a whatever easement, and you want to issue an endorsement, you can issue an endorsement for those, no problem. If you're doing an identified risk, which requires underwriting approval, and we're only doing this, like say you have a broad situation of covenants and restrictions, but you're only giving insurance on this particular thing. Say the setback line is violated and that's all you want to give. Then you're going to do an identified risk. You can identify the actual risk and put that on its own endorsement. You can have 3, 4 identified risk endorsements. Those would all be separate. So for every single particular risk that you're doing, you would have its own endorsement. For things that are general and you're just saying, okay, I want to give affirmative insurance on these easements and there's nothing wrong with them and the building doesn't lie on them or anything like that, you can just give one general endorsement. And most of these endorsements are for that purpose. But, as Vince was saying, there's so many different 9s and 28s. Those you're going to have to pick and choose. You might be able to issue this for this issue and that for that issue. And yes, you would issue 2 separate endorsements for those as well if they're different scenarios. But in general, if you're doing a general covenants and restrictions or general easements, then you can use 1 endorsement. So that was a very good question. Trying to see if I have anything else.
Catherine, does this have any effect? Does the manual have any effect on the compliance responsibility with regards to, notices that you include with the owner's policy or loan policy, things like notice of availability? Are there any substantive changes being made in connection with that?
There's no real change in that. Just make sure you have them. I've done some underwriting audits where the notice of availability was missing or the charges one was missing, and those are really by regulation. So please just make sure you have them, but there's really no change in that regard for those. Just to remember, you're not going to have a market value rider affidavit for TOPEs anymore.
At least until we hear more.
Exactly.
And the other good thing, there's so many changes being made in the manual, but the one good thing is, and it's a significant thing, and that the rates are not changing, so at least you're not going to, send out a whole bunch of final estimates and title bills. because of this. For the most part, this is pretty usual form filing. There's going to be additional information that you have to charge for, but you're not, you know, you're not having to go to your software providers and make sure that they've updated all their calculators. At least not the title insurance company. And the other good thing I think about this is that, you know, with the introduction of these endorsements, I think you might see other types of policies that you see elsewhere maybe start getting ordered here. Things perhaps even like the loan policy. Just an overall increased familiarity and conformity with the national standards, I think is going to be a good thing for our industry. And I think
I'm sorry, go ahead.
No, I was just saying, I think we might be the last to have adopted form. So we definitely need to be running to that.
Right, but at least the lenders can't complain that we don't have endorsements anymore. I mean, we still do not have as many as other states, but we've caught up a lot. Apparently, what I've been hearing from lenders' attorneys whose closings are next week, the agent saying, well, which endorsements do you need? And they're like, I don't know. You know, they don't know either. You know, they just know they need their affirmative insurance, but they don't know where to get it either because they're not as familiar with the forms. As things nationalize and, you know, the other states tell New York, oh, by the way, you need the 9.1-06 or whatever it is, you know, then they'll say, these are the endorsements we want, and then you'll get more definitive lists. You know, once they talk to their national counterparts and the lender says, okay, this is what we usually get in the other states. This is what we want in New York now. But for now, they're just saying, just give me what I need. I don't know, you know, so you just ask them what exceptions they want. And it's never been a blanket thing. You never just throw out affirmative insurance. You wait till it's asked. And you wait until it's asked specifically. I want A, B, C, D, E for affirmative insurance and these three things on the survey reading. Okay, now we're going to give you the affirmative insurance and we're going to analyze it and see what kind of coverage we can give you. It's never to be an automatic thing. It always has to be requested. Why, you know, why give the milk away for free, right? You know, why give them affirmative insurance if they don't ask for it? So wait for they ask for it and make sure they ask for whatever they specifically want, whether it's an endorsement number or an item, and then give them the affirmative insurance.
You know, Catherine, I think you raise a very important point, and it kind of puts this whole thing in context too. You know, these ALTA forms are from our National Settlement Service agents are familiar with these forms. You know, companies that are doing multi-state operations are used to providing these forms. But in New York, you know, the typical settlement agent is a bank attorney, a New York attorney. And that New York attorney very likely could have only had experience with New York transactions. And so, you know, it could require some education and selling to the bank attorney to make them understand that these coverages that they've up to now gotten in the form of, you know, free form insurance, they exist, but they exist in, you know, they exist in promulgated forms with boilerplate. You know, we in New York State, we're not the only ones with fences and hedges and adverse possession laws. So these are issues that come up across the country, and the country has come up with solutions to them. But you know, our population of lender representatives is actually, you know, probably more local than is typically the case. But
Right.
what you said could help remind me of that.
And we all know lenders attorneys, and we all know old school lenders attorneys, and they're going to try to force you. Some of them are going to say, well, I don't care. I want my affirmative insurance that I always get. And you can't be bullied by that. You cannot give affirmative insurance. It's right in the rate manual. The DFS has approved this. You can't say, oh my God, just to get them off my back, let me just give them affirmative insurance. Let me just stick it in the general endorsement or the identified risk endorsement. You can't. You know, you tell them it has to be in by endorsement, it has to be paid for, and we cannot give affirmative insurance. Do not let yourself get bullied. If you have a problem with a lender's attorney, you could always refer them to one of us. But, you know, don't make the mistake of doing something regretful that you're going to give them affirmative insurance in your policy and violate the rules of the TIRSA manual. Find an endorsement that suits their situation, put it on your bill, and that's all you can do for them. And like I said, the identified risk and the standard endorsements are not to be used for the Wild West. The standard endorsement can only be used for 3 purposes: amending or supplementing a policy, party walls with exact language from the manual, and options with language from the exact manual. You cannot do anything else with the standard endorsement. That's the one you usually use to amend an endorsement after a policy has been issued, amend a policy after it's been issued.
Yeah.
Now, you can still do that, but there are 2 more things in it because they didn't know where to put party walls or options. And they didn't want to make their own endorsements, so they stuck it in the standard endorsement. That's all it can be used for. You cannot just throw affirmative language on this thing. Same thing with identified risk. We have to be made aware of the identified risk you are trying to put. Most of the situations you have are in an endorsement somewhere. So identified risk should just be to limit, like I said, to limit. If there's 5 covenants or restrictions and you only want to give affirmative coverage on 1, you would do an identified risk endorsement saying we're only covering this one. But that really has to be crafted by the underwriter and not, you know, a garbage pail of, you know, throwing in whatever you can. So just be careful with those 2 endorsements. Those 2 endorsements are very specific as to what they can do. And they can't just be because someone asked you to give affirmative insurance and you want them to shut up.
Catherine, I think you were saying standard endorsement. I think you were referring to the general endorsement.
General, yes, I'm sorry. General standard. They're synonyms. But yes, it's the general endorsement. Thank you, Vince.
Right. Oh, you know, one thing that you mentioned, Catherine, that reminded me is that, you know, to those of you that might be wondering, well, why do I need to get an underwriter approval for this endorsement or something, or why can't I give affirmative insurance? And, you know, we as members of TIRSA, so, you know, our company as the insurer is a rate subscribing member of TIRSA. And so TIRSA files the manual on behalf of all the different title companies. And so we're actually working, you know, we're bound by that manual. Unless we were to file a deviation, which we wouldn't want to do, we have to abide by that manual. So that manual says underwriter approval is required for such and so. So we're trying to come up with procedures to enable that to happen. On the manual says no free form of affirmative insurance is possible. So we have to abide by that. And as agents, we have to ensure you all abide by that. So it's not something that we just decided to do. It's something that has happened big picture, and we all have to get used to it. And we don't have any choice in the matter. And unless we were to file some other type of policy filing, we have to abide by what's been filed.
Any further questions? Anything on your side, Drew?
Nope, I don't see any additional questions.
All right, there's going to be a million questions in the next week or 2 or the next month or 2. You know, please just send them all to us and we'll you know, answer them as quickly as we can. You know, it is a huge amount of information, even for us. And, you know, we're just going to try our best to give you the most information that we can so that you can help yourself and learn about what needs to be done.
Oh, I'm sorry, Catherine, I'm not sure. Did you see Loretta Giglio's questions here?
I do not see anything in the chat.
No, okay. So Loretta had a few questions, comments. So reports are out and haven't closed. Do we need to change all our reports? What about closings on October 1st, for instance? Thanks for your info.
Yeah, the answer to that is yes. You will have to change your reports to, for things you may have prepared in August or September to reflect that there's no affirmative insurance there. So if you have a condo exception that still has a encroachment of units language, or you're using a refinance search, covenant restriction catch-all, you will have to remove them. So it is a bit of a big deal. You may just want to do a memo to all your clients instead, or in the meantime, saying if you have received a title report in the past 2 months or 3 months or a year that has affirmative insurance, please be advised that that is not all now redacted. That is all gone. Maybe something general like that as well, so that they know whatever they have, don't rely on the affirmative language. It will not be there at the closing. We'll have to figure something else out. We'll be giving you endorsements instead.
There's one thing I guess I would mention, since I get a fair number of questions about continuation of insurance. That's something that has, in New York, it's something that really it's a combination of looking at the policy and the manual. So when you get a chance to look at these new 2021 policies, take a look at the continuation of insurance, and then also take a look at section 34 of this new TIRSA manual. And by looking at both of those things together, you'll have a good understanding of the subject of continuation of insurance.
Right, and a point about this also is use the manual, know the manual, love the manual. It has so much information in it that you guys ask questions on every day. Is there a continuation insurance if the husband conveys to the wife for no consideration? The different rules, how many contins do I get with a construction loan, and how much can I charge afterwards? What's the survey language I have to put in a commercial property policy if I don't have a survey? All this is in the manual itself. So, know the manual and love the manual, and read the endorsements and read the rules and regulations, and, just keep it with you. A lot of the questions you have are right in there. What are the conditions for refinance 12B? Whatever it is, everything is right at your disposal, and you should really get to know your manual.
Catherine, I think we've talked before, but even though there were a good number of amendments to certain parts of the manual, like the refinance rate, functionally though, they still essentially operate the same way. They tried to clarify the language, but I didn't see anything in that. I didn't see anything in those revisions that actually caused the calculations themselves to change or the rules to change.
Yeah, that is true. A lot of the manual wasn't touched. It was just kind of cleaned up a little. Things were clarified. We have some standard definitions that have, gone through the forms and the endorsements, but a lot of it hasn't changed. The big subject here is the endorsements, the forms itself, the policy jackets. Things have changed, but not as substantially as you would think. They've been modernized, the policy jackets, to have electronic provisions in it. Like if you email a policy, it's the same as if you have a live written one in your hands. So a lot of that hasn't changed. It's really just this huge bulk of endorsements that's kind of throwing everyone on their edge. But it's all good. We'll get through it. And, now we just have to figure out how, you know, what endorsements we need for what situations. And like I said, we're kind of trying to do a cheat sheet. So if you usually give this language, then use that endorsement. But you know, that you can do on your own as well. You can say, I usually give whatever this exception is. Let me go find it. And you can find the clause in whatever endorsement that you need. But we're going to help you with that. Any other questions? And Vince and I are available. You know, if you want to email us some further questions, we'll be happy to answer them. We just wanted to get you together on this date before October 1st so that we can collect all the questions that, you know, you may have that someone else has asked and just answer them in a group setting.
Well, thank you, Catherine. I mean, I think a lot of the explanations we've given today, I mean, they clarify not just the new manual, but you know, a lot of these subjects are really general underwriting subjects, and it's always a good thing when we get a chance to kind of revisit them and restate them. And I'm glad we got a good number of questions over the week to bring up a bunch of subjects. And if anybody has anything else, please feel free to send us emails, give us a ring. We may or may not again do something in this format, but we will continue to keep you apprised. Drew, I think we're going to turn it back over to you to close us out.
Great. Turn this back on. Thanks for everyone's participation. Thank you for a couple extra emails in your inbox. This was a lot of work, but it's very important stuff. The video links will go out in one recap email, and then the guide will be sent out shortly as well. So esecuritytitle.com will have the video links if you want to revisit them after the email has been buried in your inbox. Be on the YouTube page as well. But that's all I have. Thanks everyone for hanging out with us for 3 weeks. Happy almost spooky season, and look forward to all the candy in everyone's offices. So special thanks again to Vince and Catherine for all their work, and hope you all appreciate everything that went into this. So hope you have a nice rest of your Friday, and talk to you soon.
Thank you so much.
Thanks.